I want us to shift our attention very quickly to attempted murder, which is covered under Section 220 and 221 of the Penal Code. So, what is attempted murder? Now, attempted murder occurs where a person unlawfully attempts to cause the death of another or with intent to cause death performs an act or omission likely to endanger life. So, the simple definition of attempted murder is simply an act endangering life combined with the intention to kill. Now, what are some of the elements of attempted murder? For attempted murder to exist, the prosecution must prove a number of things. They must first prove the actus reus. That is an act or omission that goes beyond preparation and endangers human life and is directed towards killing another person. The prosecution must also prove another element called the mens rea, so that there must be a positive intention to kill. An important rule to remember here is that intent to cause grievous harm alone is not sufficient. It must be intent to cause death. So I want us to dive into the actus rea of attempted murder. So the accused must perform an act more than just preparation, but short of completion. If you look at the case of Rex versus Garu Ayub of 1924, the facts of this particular case were that the accused approached the victim with a loaded rifle and was restrained while raising the gun and reaching for the trigger. And so the issue in this case was, when does preparation become an attempt? And the rule is that attempt begins when conduct goes beyond preparation towards commission of an offense. And the analysis of this particular case was that the accused had not yet performed an overt act sufficient to amount to attempt. And so the conclusion of the case was that he was acquitted of attempted murder. Now, I want us to dive deeper into the mens rea of attempted murder. And here we have intention to kill. Now, the essential ingredient when it comes to the mens rea of attempted murder is the positive intention to unlawfully cause death, so that anything less than this is not attempted murder. If you look at the case of Rex versus Gwembazi, son of Mukonzo of 1943, the facts of this case were that there was an issue that concerned, the accused mental element in attempted murder prosecution. And so the issue was, what mental element must prosecution prove? And so the rule is that attempted murder requires positive intention to kill. And the analysis of this particular case was that the court emphasized necessity of proving intention to cause death. And the conclusion of this case was that intention to kill is an essential ingredient. We also have the case of Cheriot versus Republic of 1976, and the facts of this particular case were that the accused intended to kill one person, but instead attacked another person with a spear and missed. And so the issue in this case was, can intention transfer to another victim in attempted murder? And the rule is that attempted murder requires deliberate intention manifested through an overt act. And the analysis of this particular case was that the accused formed intention to kill the second victim and acted upon it. So the conclusion of the case was that the conviction was actually upheld. There's also the idea of positive proof of intention to kill when it comes to attempted murder. And the important principle to remember here is that Even if death would have occurred had injuries been fatal, the prosecution still must prove intent to kill. If you look at the case of Rex versus Luceru Wandera, son of Wandera of 1948, the facts of this particular case was that the accused was charged with attempted murder after assaulting the victim. And the issue was, is proof that act could have caused death sufficient? And the rule is that must prove actual intention, to cause death, not merely dangerous conduct. And so the analysis of this particular case was that the court stressed the need for specific intention. And the conclusion of this case was that positive intention is required for conviction. We also have the idea of intention to kill that can be inferred from fact. And courts here consider, the weapon used, the manner of attack, the body part targeted, and also the surrounding circumstances. If you look at the case of Ahmed Mohamed Said versus Regiman of 1956, the facts of this particular case were that the accused was charged with attempted murder based on dangerous conduct. And the issue was, can intention be inferred from circumstances? And the rule is that courts must determine whether facts support inference of intention to kill. And the analysis of this particular case was that the dangerous conduct was capable of causing death, can also be justified through, inference. And the conclusion of this case was that intent may be inferred from the evidence presented. We also have the idea of conviction for related offenses covered under Section 179 of the Penal Code, so that if intention to kill is not proved, courts may substitute conviction with things like grievous harm, with things like assault, and other cognate offenses. If you look at the case of Mustafa Daga, son of Andu versus Rex of 1950, the facts of this particular case was that the accused was convicted of attempted murder. And the issue was intention to kill established? And the rule is that where intention to kill is not proved, then conviction must be substituted. And so the analysis of this particular case was that the evidence showed grievous harm, but not intent to kill. And the conclusion of this particular case was that the conviction was substituted with grievous bodily harm. We also have the idea of provocation and attempted murder. So that provocation is not a defense to attempted murder, but it can reduce the sentence. If you look at the case of Rex versus Luceru Wandera, son of Wandera of 1948, the facts of the case was that the accused relied on a provocation defense. And the issue was that, does provocation bar conviction? And the rule is that provocation does not prevent conviction where intent to kill exists. And the analysis of this particular case was that intent remained present despite provocation. And the conclusion of this case was that the provocation was only relevant in mitigation. Now, I want us to look at the penalty for attempted murder as covered under Section 220 and 221 of the Penal Code. So that the maximum sentence for attempted murder is life imprisonment, and the sentence depends on injuries caused, it depends on weapon used, and it depends also on circumstances of the offense. And here we have the case of Cheriot versus Republic of 1976. And the facts of this particular case were that the trial court sentenced the accused to 7 years imprisonment. And so the issue was the sentence appropriate? And the rule is that courts may reduce sentence based on circumstances. And the analysis of this particular case was that the victim suffered no physical injury. so that the conclusion of the case was that the sentence was reduced to 4 years imprisonment. We also have the idea of accessories after the fact of murder as covered in section 222 of the Penal Code. And the definition of accessory after the fact is simply a person who assists the offender after murder, knowing offense has been committed. And a good example is hiding the offender, helping the offender escape, and also destroying evidence. And the penalty for this usually is life imprisonment. Now, there is a difference between principals and accessories when it comes to murder. So that the principals include, the actual killers, they include aiders, and they also include abettors. Now, the punishment for the principals of murder is the same as the murderers. Now, remember, the accessories after the fact, offer assistance after death occurs. And the punishment is usually life imprisonment. If you look at the case of Rex versus Mutono, son of Luigo of 1936, the facts of this particular case was an issue that concerned whether assistance before death qualifies as accessory after the fact. And the issue is that when does accessory liability arise? And the rule is that the person becomes accessory after the fact only after death occurs. And the analysis of this particular case was that assistance before death cannot constitute accessory liability. And the conclusion of this case was that accessory liability arises only after death. Now, there are a number of things I want you to remember when it comes to attempted murder. Remember, to prove attempted murder, the prosecution must show a number of things. They must show an overt act beyond preparation. They must show an act endangering life. They must show specific intention to kill. And they must also show manifestation of intent through conduct. So that if intention to kill is absent, then we have substitute offenses, and a good example is grievous bodily harm. So that is all I have as far as attempted murder is concerned. And in our next legal lesson, we are going to talk about manslaughter. If it is your first time here, make sure to follow this channel and to subscribe for more legal lessons.